morning and welcome to the first leg of the India development debate right here on ET Now. I'm Supriya, Shrinate. Tonight we are going to discuss the IBC resolution and the changes that have been made there. But coming up next at 9:30 p.m. is the second edition of the India development debate that talks about the jobs. We continue our 4-year report card series of the Modi government, and tonight at 9:30 p.m. we put the focus on jobs and ask the crucial question: where are the jobs? But right up, let's take it to the big discussion right now. Big bang changes in Insolvency and Bankruptcy Code have got the Cabinet's nod. Relief for MSMEs and home buyers is on the cards, and the much-awaited IBC reboot has finally happened. After the meeting of the Union Cabinet, Law Minister Ravi Shankar Prasad said the government has approved some key changes to the Insolvency and Bankruptcy Code. He refused to give any more details. Some of the recommendations made by a 14-member panel headed by Corporate Affairs Secretary Injeti Srinivas have been accepted, although the minister did not give out specifics. We learned from top sources that the green line has been given to a proposal to treat home buyers as financial creditors, which will allow them to participate in insolvency proceedings. Another key change is the relaxation in clause 29A of the IBC, but only for MSMEs. Remember, this clause has been widely debated, and the question is, has the IBC amendment left a lot to desire? Looking at legal tangles, is there enough buffer for home buyers? Also, with the new changes providing a safety net for MSMEs that may have gone belly up for no fault of theirs. The big IBC reboot is the first topic of discussion and debate right here on the India Development Debate. Let's take it across to a stellar panel that's joining us. Maithili Busnurmat, Consulting Editor, ET Now, Alok Dheer, Managing Partner, Dheer & Dheer Associates, and Rajen Chitale, Managing Partner, Chitale Associates. Thanks each one of you for being with us. And I do have to first begin talking to you, Maithili. There is a lot that has happened, and this is of course source-based information, so just for the benefit of our viewers, I'm going to quickly tell 3 or 4 things that we know from top sources in the government of India on this. The first is that home buyers have now been put at par with financial creditors, so this ring fences them. 29A of the IBC has been changed for the MSMEs, so MSMEs can come back, and defaulting MSMEs can come back and bid for their own companies. The third and a very crucial change is that only 66% voting is required in crucial cases instead of the 75%, and 50% for routine cases. Remember, voting percentage from bankers from 75 to 66% for crucial cases and 55 for routine cases. Let's take this across to Maithili Busnurmat, and Maithili, just set the context for us. Let's begin step by step. Let's talk about the home buyers first. How big a news is this really for the home buyers? Them being treated as financial creditors, putting them at par with banks and institutional creditors in priority of recovering dues. Does this ring fence them against errant realtors?
Well, I'm afraid this is a remedy which does not really quite, I wouldn't call it worse than the disease, but it's a pretty bad remedy. As if you're a home buyer, yes, you would feel that some satisfaction that you have been put on par with financial creditors. But let's not forget that the IBC had a very clear waterfall. That means it had a very clear priority in terms of who should be paid as and when the company goes in for liquidation or resolution in the case of bankruptcy. So clearly you had placed secure creditors up front, and their rights were to be protected first of all. So when you get home buyers and put them on par with financial creditors, that goes against the very grain of the IBC. Home buyers who have paid up money and have not got their houses, they have a separate recourse under civil law, under RERA, the Real Estate Regulatory Act. So those are the remedies that are available to them. By mixing them up with the secure traders under the IBC, I think you have done injustice both to the home buyers as well as to the secure traders, because secure traders, how do they work? They might be willing to take a haircut in order to find a solution. Will the home buyers be willing to take a haircut? No. How do the home buyers, even if can they get together? Because mind you, these are people who perhaps don't even know each other. So how are they going to get together and actually appoint one person to represent them on the committee of creditors? Will that person be able to qualify to take part in the discussions? If the company goes in for liquidation, what happens to the home buyers? So I'm afraid by getting home buyers and putting them on par with financial creditors, you have done injustice to the IBC, to the secured creditors, and ultimately to the home buyers, because they are not going to be better off. They had different remedies, and the solution was to ensure that those remedies are quickly enforced by ensuring that the legal process is completed quickly. So, I am afraid this is one answer which I am not happy at all. And finally, we are going to kind of realize that this is a remedy which is no better than what we had in the past. It might in fact be worse than the disease.
Okay, let me just take this across to Mr. Chittale, because Maithili is not impressed with what has been done for home buyers. Mr. Chittale, what's your own view? Do you believe this ring fences the home buyers, or do you, like Maithili, believes this puts them in another category that they have no business being? Because there are many who are justifying this by saying that it ends the inherent contradiction between IBC and RERA. IBC allows companies to file for bankruptcy to provide relief to debtors or creditors. RERA looks at providing relief for home buyers. In that sense, people are justifying this. But do you agree with Maithili that perhaps it's going to be very tough for these home buyers? These are potential home residents. They don't know each other from Adams. How are they going to get together and bargain on their position?
I think the issue is twofold. One is how do they get the ability to come together, but that I think is an issue which can be sorted out. The real issue is there is this whole tussle and a tug of war between the emotive aspect of home buyers' distress of not having got what they really bargained for, versus the whole thesis and the underpinning under the IBC of giving priority to secured lenders. So, at the end of the day, I think this is somewhat of a political social response to a very difficult problem, and therefore, at the minimum, they are being put on par with financial creditors, though it really does not deliver what they need to, and at some level it also compromises the position of secured lenders. This may be partly justified from the standpoint that it is the emotive aspect of the home buyer's life savings being at stake, and he already having suffered and so on and so forth. But clearly this is I would not say that this is an elegant solution, but from a political social perspective, this is at least a change which I think is a step in the direction which one would have thought was required, given the fact that even the Supreme Court in some of the cases has been seized with this particular issue. Coming to RERA, I think RERA does provide a meaningful framework, but that is going forward. Currently, we have a lot of cases under the IBC where there are distressed situations for buyers who have already bought in premises. So, I think RERA is prospective to the extent that it protects the home buyers henceforward in terms of the money they have deposited to lie in a separate account, and that would ensure that that money is kind of ring fenced from the problems of the company, but nonetheless it does not really address the cases which are currently in the NCLT.
Alok Dheer, there are both our experts, both Maithili and Mr. Chittale, do believe that this is perhaps a more political, social sort of a reaction to a problem which also compromises the secured lenders, the banks and the financial institutions a little bit. A, what is your own take on this? And B, I want to also take this discussion forward, because we still don't know if this is prospective. We don't know if this comes into effect from now on, or will this apply retrospectively, because given how some really big realtors are facing insolvency proceedings, and this entire move has been triggered by home buyers being in courts, petitioning the government, leaving home buyers who've put their money in flux. I mean, I'm just trying to understand, will this serve a purpose, if at all it has to, if it's prospective? Do you believe this needs to be done retrospectively?
I think I agree, in fact, with Maithili as well as with Mr. Chittale. The solution which has been put is certainly not elegant and doesn't cover the interests of all concerned. However, the compulsions which the government was facing both at the social and political end with respect to the clamour from the large number and large section of the home buyers who have been put to a great amount of personal pain insofar as the developers is concerned, who have not been able to build them their houses despite having taken substantial amounts of monies from them. So there was a serious problem, and this is the response that the government has to try to a certain extent ameliorate the problem of the home buyers. However, by putting them as financial creditors at par with other other financial creditors, which may be banks and financial institutions, may not really be a solution for them. The current situation is that in the JP matter, for example, the Supreme Court has put its shield of protection around them and has been saying that whether the IBC needs to be overridden or otherwise, they will make sure that the home buyers get their homes and they get justice. In a situation where they are treated as part of financial creditors, they will be forced to take a haircut at par with what are the haircut the other financial other financial creditors are taking. In the CIRP process, all of them are sitting at the same table with equivalent pro rata equivalent voting rights. However, if the scheme is not, if the resolution plan is not approved, the matter goes down to section 53, in which case they will be treated as unsecured creditors. I do not know whether the ordinance at this stage is considering treating them as secured creditors or otherwise, but if they are treated as unsecured creditors, even if they are financial creditors, they will be fourth or fifth in the hierarchy for getting their dues. Now,
the details whether they're secured or unsecured.
There certainly has been there, which is prospective in nature.
Okay. No, we still don't have the details whether they'll be secured or unsecured creditors, and which is why I don't want to hazard a guess there. But very quickly finish your point, because I want to move on to the voting rights, sir. The retrospective and the prospective bit.
So I would say this is a problem also for the bankers, because it would be very difficult for bankers to justify lending to real estate projects, particularly with respect to home developments. And at the same time, if that was to happen, then we'd have done a great disservice to the economy, because who would want to come forward to build houses and do housing developments? On the other hand, if the home buyers don't get respite and don't get relief after having put in their money, then clearly this is not justice insofar as they are concerned. So the government has tried to find a middle ground. How this will pan out, whether it will get justice for them, whether it will be something which the bankers are willing to proceed and give lending to such projects in future, remains to be seen.
Maithili, I'm going to come to you and touch upon the other aspect of the IBC amendment that has been made. And again, this is completely source-based information. The government hasn't put out an official communication on this. I think they're waiting for the ordinance to be promulgated by the President. But Maithili, if I may come to you, and this has to do with the voting percentage from bankers. The voting threshold has been brought down from 75% to 66% in the crucial cases, and a lot lesser, 55% is my understanding, on the routine cases. Do you believe this serves well? Because even in the US bankruptcy chapter, my own understanding is that liquidation cases, the voting required is 70 to 71%. So are we moving towards the global best practice there? We've seen cases in Alok Industries and RI, we've seen cases where things couldn't take off because the entity couldn't meet that 75%. I think RL got to 70%. So is 66% a good move in the right direction? You think it will help in more resolution of cases?
Well, yes, this should help. In fact, of the 3 measures that you have announced in the ordinance, whatever source was information we have, I think this perhaps is one on which I am in agreement with, because very often it becomes very difficult to get agreement among the committee of creditors, because not all committee of creditors have the same kind of resources and the same kind of security, particularly because of the breakdown of the consortium discipline. Each one of them perhaps almost fights on its hits or on its own, each bank. So to that extent, I think the lowering of the threshold for agreement from 75 to 60% and 50% in the case of routine cases, I think that is a good move. It should ensure speedier resolution. So to that extent, I am all for it.
Rajan Chitra, you want to come in on that? Do you believe this is going to ensure speedier resolution, because lesser number of consent, I mean lower consent will be required, not 75 but 66% and 51% for routine cases?
Oh, absolutely. I think it's not about routine cases. There are 2 parts of this. Lowering to 66 applies to the critical decisions which are relating to approval of the resolution plan and 2 or 3 other items. And all the rest, it is a majority vote based on value. I think this is a very positive development. I agree with Maithili that this is one of the more positive changes which has been, which was recommended by the committee, and which perhaps is going to form a part of the ordinance. This will clearly help resolutions in cases where we have seen quite a few cases in which the margin by which the vote did not go through was relatively narrow. And indeed, in 2 or 3 cases, if indeed the margin was a 66% vote, then the resolution plan would have gone through. So clearly, this is a very positive development.
I do want to move on to the third part of this entire amendment, because I think I want to devote some substantial time to talk about what has not been done, and that is 29A amendment for the large firms. But I'll move on to the third part of it, and Alokdhir, coming to you. You know, MSMEs have been allowed, the promoters of MSMEs can come in and bid for their own companies. My own sense is this is being done because unlike the big firms that have a beeline of strategic and, you know, all kinds of investors, I don't think MSMEs find that. But is this again cosmetic? Do you believe this is going to have this is going to make a big difference on the ground? Because what is an MSME? I mean, MSME is a turnover of over 5 crore and plant and machinery worth 25 lakhs. That's quite a blip, is it not? Alokdhir?
Yeah, I think there is a contradiction here, and the contradiction is that we are now creating a differentia between the companies which are larger, which are subjected to a more rigorous regime under 29A and a disqualification regime, and then there is the MSMEs, the smaller companies, where the 29A the provisions of 29A have been diluted very significantly, and only in cases where there is no wrongdoing, or in that sense there is no willful default, in those cases the promoters will be entitled to bid. So the moral ground on which this particular 29A was framed has been diluted to a certain extent. Having said that, clearly in the MSME and the small cases that we are dealing with, there are no bidders. People don't come forward and make bids for these cases, and the banks stand to lose a significant amount on account of no resolution plans coming forward, and in the liquidation also not much expectation is there for getting substantive recoveries. So to that extent, diluting 29A will become very meaningful, and a very large chunk of cases which is small but very large in numbers will be able to find revival and rehabilitation, and perhaps save jobs, and perhaps in that sense will be beneficial for the economy in the long run.
Let's turn focus and let's talk about what has not been done and where there is such a huge clamor. Maithili, I will start with you. 29A, and you know, everybody thought 29A needs to be tweaked. This blanket ban on related parties, on promoters, on financial institutions, on stress funds, all of that is not working, but the government hasn't changed that. Why do you believe that has not happened? While the government, and Alokdhir is right, that you know, suddenly there is a differentiation between the big and the small defaulters. Why do you believe that the government is not changing 29A? Is there a moral hazard? Is it more because of political reasons? Or does the government really want to test a few cases like Tata Bhushan, wants to prove that some big cases can go in, wants to change the very, very bad credit discipline of Indian industry, and then perhaps bring in a change? What according to you is delaying the change of 29A?
Well, unfortunately, I think the jibe of Soot Woot Sarkar seems to have stuck, and this is something that the government really should not have been bothered about, because 29A is so restrictive, which is why you see virtually anybody who could possibly bid for the company is ruled out. So in fact, what the committee has suggested a drastic pruning of the ineligibility conditions under section 29A. They had said the rule that you have about connected parties, related parties, all that should go. In fact, the committee did not go far enough in my view, because they talked about NPAs. Any account which has been NPA, any cooperative would be an NPA for more than a year could not bid. But even so, the committee had made a number of wise recommendations, which even if they didn't go the whole hog, was certainly far better than what it is today. But unfortunately, the government doesn't seem to have considered that at all. And in the process, what we are going to find is that a large number of companies, where problematic companies, where there could have been a resolution, which could have been salvaged, they perhaps will have to go into insolvency, precisely because the government just doesn't have the courage. They should take courage in their hands and say that this 29A, which is introduced like earlier through first an ordinance and then through legislature, should not have been there in the first place at all, needed a complete revamp. Unfortunately, the government has done this only in the case of MSMEs, and in the process what you've done, in fact, if I could just come in over there, in the process what you've done, you've created an unintended incentive for companies to remain small, because the moment you cease to be an MSME, then all these benefits that are being extended to MSMEs no longer apply to you. Unfortunately, the government has not chosen to do this, I would think here because of political considerations.
But you know, it's also interesting that the 14-member Insolvency Law Committee that was headed by the MCA Secretary had made a plethora of suggestions, and some of what has been accepted is from those recommendations. Of course, they had suggested very, very categorically that 29A clause in the insolvency law makes it has to be made less stringent, and related parties should be allowed to bid. Alok Dheer, I don't want to ask you a more generic question on why do you believe the government has done so, but do you believe at some stage the government will have to at least allow, say, stress funds, because they will have NPAs on these books. They will have to allow financial institutions associated, and the very stringent laws. I mean, you know, if you actually look at the more detailed 29A, it talks about proceedings in a court outside India is also a ground for disqualification. Do you believe that needs to go before we are even looking at making an overhaul of 29A? And will that help?
Well, I would tend to agree with Maithili. 29A as incorporated through an ordinance and again later through the amendment to the IBC is itself a bit questionable. Nowhere in the rest of the world we have any such ineligibilities, and I think the government was motivated by a political consideration, and they have been showing that they are moving against crony capitalism, and they want to avoid people who have been gaming the system or have been responsible for the companies becoming NPAs to get these companies back at a fraction of their values. So there was to a certain extent a moral justification, a political justification for 29A. But if you look at it from a commercial and an economic standpoint, there is no justification for a legislation of this nature under the commercial provisions of the IBC was framed as a very commercial legislation. Now the problem that is arising is that frankly, the current dispensation disallows just about everybody, even in the large cases without taking names. Most of the bidders, in some sense or the other, we find our allegations are being made that they are hit by the provisions of 29A. The net is so wide, and as lawyers, sometimes when we try to determine for the resolution professionals or for the COC whether a particular entity is covered under 29A or not, at some point of time we just give up because there is no answer, and the step after step and you have so many layers and layers and layers of people that you are getting covered that it becomes impossible beyond a time to see whether it gets covered under 29A. And then when the matter comes to court, somebody comes up with some sort of an issue which is there, which says that in some other country there is some law that has been infringed, which is impossible to find out in the first place.
Okay, Alok, I'll have to come in there because I think I'll take a quick last closing comment from Rajendra Chitale, and I really think, you know, how does one make this choice? Because you've got data that suggests that for fear of losing control, 2,100 companies have settled about 83,000 crore bank dues. Then you've got figures of the 35,000 crore NPA that has been wiped out because of the Tata Bhushan deal. But you also have instances like Alok Industries that went for about 5 to 10% of its asset value, where there was a significant asset value erosion. How do you balance the kind of traction that some deals are getting vis-a-vis the asset value erosion that's happening on account of 29A on the others?
Well, I think 29A at its core, the basic essence was not really touched by the committee itself, and to the extent that we are discussing what changes have been brought in by the ordinance, we are actually limited in the context of 29A by the relatively limited and circumspect changes which were recommended by the committee itself. And given that this is the construct which the committee itself followed, that they did not try to address some of the issues at the core of 29A, I think they simply confined themselves to changes relating to the collateral unintended damage that it was going to cause on account of persons acting in concert being brought in and the connected persons to them being brought in. So financial investors which are relatively unrelated to the promoters, etc., would have brought in. So they themselves were very circumspect in the changes. I think those changes could have been brought in. At the very core, I think in the current context of where we stand in terms of moral hazards, I think the core of 29A would perhaps need to be there, notwithstanding the fact that there would be value erosion in some cases, but I think therefore to say, okay, we will reward the promoter who has really brought the company to this stage might be a very difficult and unpalatable situation in today's context.
Indeed, there is a moral hazard in not letting letting promoters back in who've landed us here. We're not talking about NPA levels of 1 lakh, 2 lakh crore rupees. We're talking about NPA levels of over 8 lakh crore rupees. Yes, there's some resolution that's happening, but I think Indian industry also needs to understand that debt is not equity, and you've got to change the debt contract, as Raghuram Rajan used to say. But having said that, stringent laws are not going to land us anywhere, and the government needs to be agile and needs to keep changing laws as and when required. But thanks very much for being with us, Maithili Basudemath, Rajan Chitale and Mr. Alokji. Thanks very much for being with us on this edition of the India Development Debate. We take a quick breather and we come back next with our 4-year report card. That's a special ET Now series, and we are putting the spotlight on where are the jobs.